I wrote a paper that kind of introduces today's session. And that means I'm going to talk about the question about the future of computational law, which means I will first say something about how we could define this. Then I will raise the question whether the rule of law would be computational, what a computational law, rule of law would mean. And then I will sum up some of the challenges here and try to do that in a way that groups the papers, but that's a little bit artificial. Let's see. Anyway, it allows me to raise some issues. So I'm going to define computational law in terms of legal effect, because the attribution of legal effect is what makes something legal. If I buy bread at the bakery, then if I have to pay something and somebody has to deliver me bread, that's not just because it's a moral obligation or something like that. It is because there is this specific legal effect, the obligation, the legal obligation to deliver the bread to me and for me to pay. And if those legal obligations are not kept, I could eventually go to court. This is how the law actually works. Now, we could say that computational law would mean that legal effect is directly attributed to the output of legal technologies. So to a machine learning system that predicts legal judgment, that the court says, well, instead of going through the whole thing, we will feed the data into the system. It has been checked. It gets things right in 99% of the cases. Performance metric accuracy, and that 1%, well, probably human lawyers or human judges also get it wrong sometimes, so we're actually going to do very well. This is one particular way of really replacing law as we know it today by another type of law. As I wrote in the paper, this is not really something that most people would advocate at this moment in our jurisdictions. But in China, for instance, this is already happening. And it is advocated as being more fair, more equal, more efficient, and more effective. It's a very large country, many different jurisdictions under the heading of one jurisdiction. Another way of looking at computational law is saying, okay, if this is computational law, then there must be something else. That is a set of consequential legal technologies. I'm again borrowing the term from Kapoor, Henderson, and Narayanan, that impact the constitution of modern positive law. So if you use search engines like Westlaw or LexisNexis, you are actually already using a whole set of legal technologies that you may think, well, it's a nice tool. And the point about legal effect is that it is a performative effect, not a causal effect. If the civil servant tells, let's say, two men, I now declare you husband and husband, the civil servant is not causing them to get married, I hope. It's also not that he derived from logic that these people are going to be married. The decision is attribution of legal effect to the fact that he declares them married. And that is what is called a performative effect. When you look at speech act theory, where this term comes from, you will see that the founding father of speech act theory, Austin, nearly all the examples he uses are legal examples. For lawyers, this is their bread and butter. This is the normal way of thinking about the law. In the light of these new technologies, it is good to remind ourselves of that very specific nature of legal effect. So the interesting thing when we say, okay, we don't want to attribute legal effect to the output of these technologies, but we're going to use them as means to do quicker search, to, for instance, generative AI, to write briefs, predictive AI, to predict whether the cases that you're citing in your brief aren't actually already overruled. All this sort of technology is now available, and it's all in the realm of search engines. Now, what is very important is that if you use these systems as tools, their output, that is going to have, obviously, because that's what you want, in the end, an effect on legal effect. And I think this is something we should investigate. Now, let's have a look at the rule of law. Could there be something like a computational rule of law? So the rule of law is, of course, a concept where people have very different understandings what it means. Some people think, and that would be a formal conception, that the law is a system of abstract general rules, and from that system you can deduce the applicable norm. And a lot has been written why this abstract and general nature of norms is key for equal cases being treated equally. So this has to do both with justice and with legal certainty. There are other conceptions of the rule of law which are usually headed under the idea of being more substantive. And that is saying, under the rule of law, we must include human rights and democratic participation. So that's the more substantive understanding. And then there is the procedural understanding of the rule of law, which says the rule of law, Montesquieu, is about countervailing powers. It's about checks and balances. So that's both more and less than the separation of powers, which I would say is a little bit an old-fashioned understanding of the rule of law. It's about countervailing powers. And basically the procedural way of looking at a rule of law is saying the other ones, the formal and the substantive one, don't mean anything if you do not have an independent court. One of the interesting things is that this makes the contestability of the attribution of legal effect key to the rule of law. Sometimes I try to explain to people that the rule of law means that the democratic legislator does not decide what the law that they enacted in our name means. Now, if you try to explain that, many people will frown. And there are political powers, political parties who contest this and say that's ridiculous. That's the power to the courts. They're not elected. But that's a misunderstanding of the idea of countervailing powers. This idea of the rule of law has a very long history, and it's based on the fact that if you give a legislator and the executive not only the power to enact norms, but also to decide in practice what they mean, then you have arbitrary rule. That's how it started. The king would have servants who spoke the law, and they spoke the law on his behalf. The adage in the Middle Ages was rex, king, lex loci. The king speaks the law via the judge. Montesquieu said, no, iudex, lex loci. So that's not the old-fashioned interpretation that he said judges are just mechanical interpreters, they're like machines. No, it's saying the last word on the law is not with the king, it's with the judge, who decides in concreto what it means. I have to move forward because otherwise I'll take the whole situation. I'll be called back by Leary, I know that. So I think from this institutionalization, so the institutional understanding of the rule of law, it should be clear that this is fundamentally incomputable. And I would refer to the wonderful book by computer scientist and philosopher Brian Counter-Smith, The Promise of Artificial Intelligence, where he explains very well this incomputability not particularly of the rule of law, but of things like human judgment. And in our journal, Mitsuhita Chirimuta, philosopher, explained the same thing, the difference between a calculation and a judgment. And she refers to Kant, saying that even in his first critique, sorry if I'm now speaking acadabra for people who are not philosophers, but Kant said if you have a rule, an abstract general rule, and then you want to apply it, you will need to make a jump. These rules do not apply themselves. You will need judgment. Anyway, so let's say that this is the key of the cubicle project and the key of modern positive law in relation to computational law. What matters is not computable in the sense of being computable in a final way. But of course we can make it computable. There's no problem. But you can always make things computable in different ways. Code-driven, data-driven, but you can use different programming languages. You can use different machine learning systems, and those systems themselves can do different things. The difference in how you make the law computable is what matters. Okay, what are the challenges that we're going to discuss today? Yes, I have to stop. This is the challenges. Cross-disciplinary collaboration, the question of access to justice and the automation of law, and rethinking legal education also in the professional sense. And I'm going to stop here. Okay.
So we have Sarah Lawsky replying, and then that's 10 minutes, and then we're going to go to a panel conversation for another 10 minutes. And we're not going to do audience until the half an hour at the end of all of the papers and responses and panels. I'm also going to get a little bit stricter, I think, with time, because I get this sense that we could all talk about this forever. So I'm going to use my phone as an alarm, and when it beeps, you're at your 10 minutes. Okay. Thanks, Sarah.
Great, thank you so much, and thank you so much for this conference as well as for this paper. So, like some of your other work, most work that you've supervised, most obviously the Legal Typologies Project, one of your contributions in this paper is to make rigorous and explicit distinctions and define clearly certain terms that are used elsewhere, maybe without as much precision. And here, as you mentioned, one of those terms is computational law. And your definition, as you mentioned, is that computational law exists when legal effect must be attributed to the output of a computational system. And you contrast that with the other use of legal technologies, where you say the legal effect depends on a decision maker, and you tie this to the rule of law. So I want to spend some time with this distinction and with the application of rule of law issues around this distinction. And I just want to be clear before I start that I really stress that what I raise here are questions that may just have straight out answers, and they aren't necessarily objections, and they're all kind of related to each other. That's dramatic.
And the earth falls.
Yes, excellent. So my first question is, what is at stake in this distinction? So why do we need to define this particular term of computational law? Is it a contested term? What work does defining it in this way do? Will this constrain certain kinds of conversations that are already occurring? Does it help us focus the conversation on an area that is particularly problematic? Who is having the conversations where we want to constrain the use of this term? So my second question, as you'll see, these are all one flows to the next, is about the definition itself. Whether there is a line between what you define as computational law and other types of technology, or whether this is maybe more of a spectrum. So on one end of the spectrum is a computer program whose outcome has the force of law, as you say. So this would be like a court case where the computer program is a judge. The decision is as final as any judge's decision. This is like in the research study on computational law, there's this discussion of Eugene Volok's article where a suitably trustworthy AI system could be promoted to the role of judge. And this is very clearly at one end of the spectrum and raises all the rule of law issues that you describe. And then at the other end of the spectrum might be, as you say, a search tool that helps a lawyer find relevant case law. And this is clearly just helping the human who ultimately even writes the brief, forget about making the decisions. But what about a situation in the middle? And here's one possibility, a computation that determines who will be subject to a tax audit. So maybe this falls into one of these two piles, or maybe it's somewhere in the middle. So I'm going to elaborate on this particular example a little bit to show what I have in mind and why I think it may edge closer in a meaningful way, edge closer towards effectively being like, not being the judge, it doesn't have a legal effect, but being closer to that. So maybe one could say, so maybe you just start at the very lowest level and say, well, look, being contacted for a tax audit isn't something that constitutes, even in itself, legal effect. I don't think that's a great argument, because once the government contacts you for a tax audit, you have to comply with their demands. So I don't think it's right to say that the government demand for information in the context of a tax audit somehow isn't law. It seems similar to the potential program that was discussed in the research study on text-driven law that the Dutch court found unconstitutional to detect social benefit fraud. So then maybe the argument itself, and I think this might have a little more potential, is that the computer output doesn't itself trigger the legal effect. So the government, some human somewhere in the government still has to take additional steps. And I think that does distinguish it from the AI judge scenario. But what if the program gives an answer that can be executed immediately without any additional input? So this is different than researching a case where you just bring up a case. And then what if the answer is in fact always implemented? So the program provides a list of people who should be audited according to the program, and then those people are always in fact audited. Maybe the program even generates the letter that's going to be sent. Why are those people in fact audited? Maybe because the system doesn't provide any way for humans to review it, or maybe because humans, after a while, say, I don't know, the list is good enough, I'm not going to look. I'm not going to actually do this. So, I'll just say bracket this, another possible way to counter this is to say, well, people can't even contest whether they can be audited, so that at least in the United States, so that's another distinction, so maybe we're less worried about accountability, but I'm not super persuaded by that. So let's just focus on this. We have a machine sort of proposing an outcome, and as a matter of fact in the world, that outcome is always enforced by the humans. And as the research study points out, you can get kind of a feedback loop here, where eventually the humans, first they don't make the decision on their own, and then they can't make the decision on their own. Ultimately they're not even trained to make the decision on their own. At any rate, the point here is this just seems to be kind of a continuum. I wouldn't classify that with the judge situation, but it also seems somehow meaningfully different to me than the research tool situation. All right, so this ties into my next question, which is you make the statement in the paper that computational law has no future in constitutional democracies, and I'm wondering whether that is a normative statement or a descriptive statement or both. Are you predicting that it will not, in fact, have any future in constitutional democracies, or are you saying it should not have any future in constitutional democracies? So let me say another way. I think you make a very strong argument that it should not have any future in constitutional democracies, so I guess I'm asking, do you also predict that it won't, or do you think that absent arguments such as the ones you make here, it might end up taking hold to some extent in constitutional democracies? For the very strong definition of computational law that's just AI judges, maybe there's one answer. If we see computational law as a continuum, maybe there's another answer. And maybe to some extent we already have computational law, depending on how it's defined in some areas in constitutional democracies. And that brings me to my next question, which is I wonder in what way the arguments that you're making apply to private law as compared to public law. So you mentioned court cases, and you also mentioned contracts where a clause stipulates that some computer code will have legal effect. And I wonder if this describes computational contracts. Sometimes they're referred to as smart contracts. I strongly object to that term. That's another topic. So even within constitutional democracies, there are smart contracts. Contracts are made by private parties. I mean, sometimes the government is a counterparty, that's a whole, but most contracts are made between private parties. The powers of the state loom behind the contract. That's what makes it a contract. But by having smart contracts, the parties are perhaps reducing, not increasing, the power of the state. The extent to which smart contracts can be contested in court might be one issue. So this is discussed in the research study on text-driven law. Part of the definition there of the rule of law is the contestability of actions or decisions in the public or private sphere that might violate rights or obligations. On the other hand, there are many parts of contracts, all contracts, that are sufficiently clear so that while they can be contested in court in the sense that anybody kind of can contest anything in court, they would never be overruled. And the terms of contracts can require, for example, arbitration, at least in the United States. So there are other ways that private parties can remove themselves from courts. And the meaning of legal norms in private contracts is largely set by private parties, not by legislatures. So again, there's no doubt that contracts invoke the power of the state. The whole point of a contract is that it is a promise, usually between private parties, that the government enforces. And it can become very serious. The enforcement of the contract might end up with the government like seizing someone's assets. The whole a contract is made by private parties behind which the government looms. And that's an enormous amount of government power. But the concerns about the power of the state seem different in the private law context. And so the rule of law argument might go through differently in the private law context. And I think there's literature about the rule of law in the private arena. So it's not that it doesn't apply, but I just think that the argument might look different there. So those are just some of the questions that arose for me while I was reading this paper, and I'm really looking forward to our discussion.
All right, would you like to, there's a lot there to answer.
Yes, so what should we do about the mic? Is there a way to put this on? This one is on? None of them is on.
This one is.
I can pick up their parts. I hope.
Sorry, everyone.
Hello. No. Is there somebody who can fix the mics?
Yes,
Somebody's coming. Okay, then I'm going
Do you want this one in the meantime?
Maybe that's for the streaming, otherwise.
Otherwise, they won't hear online.
Yeah, thank you very much. We must now avoid that the other mics don't work, so maybe if you could put them on. That we always have 4 mics on, because normally there are 3 or 4 people. They are on. Is that true? Yes, it is. Thank you very much. I will avoid answering all the questions because then it takes too much time. The first thing is, in my definition, legal effect is not at all limited to a court. So when I make a decision to conclude a contract and I enter that contract, the law attributes legal effect to that. So I think that's fantastic. Legal effect is not about courts or about public administration only. I also think that what we see now in public administration, and that's been around for a very long time, I think since the 80s, that many decisions are taken automatically, and there's some civil servants who signs them off. And hopefully lots of thought goes into the system by which this automated. It's about scaling. This is a narrative that exists for a long time. Many people talk about the Dutch issues in terms of social security. Many of those systems had nothing to do with machine learning. There was an Excel sheet somewhere where people jotted down, if you have a nationality that is not Dutch, then you're going to be investigated. People often mistake that for the Siri case, but that's another case. That's about legislation that indeed seemed to allow some sort of machine learning. So it's very good to look at that continuity. Some people think it's an argument to say, well, we always did it, so if we can scale it up a bit more, that's fine. Now, perhaps what we always did was already problematic for certain vulnerable groups, so I find that a problematic argument. The example that you give about the spectrum, that's of course a very interesting thing. So you could put this on a spectrum, but I think there is some schism. And I think in the context of European law, there are 2 things here. There's Article 22, of the GDPR that basically by default prohibits solely automated decisions that have serious impact on people. So it's an impact-directed clause, but it says solely automated. The EDPB, the European Data Protection Board, has said solely automated is also the case if the person that officially takes the decision has no idea what this is about and basically has no authority to change it. Yeah. So this is very interesting because that gives you a criteria. If the person who is taking the decision cannot explain to anybody why the decision was taken. I don't know if you speak to help desks sometimes from private enterprise or from public, but well, you know exactly what I mean. The other thing, and I think that's very interesting, is Article 14 of the proposed AI Act. Article 14 does something entirely different, though there are links. It talks about human oversight. And one of the things it says is that the person who takes a decision based on, I would say, mainly data-driven systems, and data-driven means machine learning in a very broad sense of that term, must sufficiently understand the output of the system. So it doesn't say, oh, they have to understand the algorithms and blah, blah, blah. No, it must, that person must understand in the context of the law, that output, that person must be able to reverse that decision, to take another decision. And there's even in the last clause of Article 14, that you must be able to stop the entire system. And it refers to a button, but that is just an example. We are in charge. I think Article 14 is very cleverly designed. The people who wrote that down understood that human beings should not be in the loop. That's a technical computer science term that is absolutely fine in the context of computer science, but not in the context of law. Human beings should simply be in charge. That might mean that a lot of these systems will not run, because it's not so easy for people to understand. Well, if these systems, if we as in a democracy think these systems shouldn't run, they shouldn't run. And actually, but that should be my last thing, if you would calculate the financial investment that has to be made in the software to buy it, and let's face it, governments always fall into the trap of saying, let's do it agile, which means that you can get a bill every week. Then there is maintenance. Then there is legacy problems. Yeah, so software is always extremely expensive. Not today, but in the long run. It has also a lot of additional costs, because if people are approached by an automated decision and basically sense no flexibility, sense that they are not heard, they are not going to behave very nice to the government or to whoever takes that sort of decision. So you have a lot of extra cost in terms of trust. So I think the concept of legal effect and the difference between direct attribution of legal effect, which the law could attribute, no problem, and the difference between using it to make decisions. My point is basically this is a little bit deceptive. Right? So we might say, oh, but we would never do that, but in China they do. And my point is actually, well, it's not that simple. Yeah.
I was going to come in and a little bit, Sarah, on one of your examples, but on this point about legal effect. There's an interesting case in Australia about what happens if there is no legal effect. So the case is called Pintarich, and it was a very simple automation process. You know how you can sort of do email macros, right, where you push one button and there's a standard letter that is produced based on the one button you push. So the bureaucrat pushes the wrong button, and the letter goes to the taxpayer. This was a tax situation, suggesting that if they do something, then the rest of the tax bill will, in a sense, be cancelled. It was the wrong text or something, but they rely on it and they do the thing. And what the court said, the majority of the court said, is it is not a decision. It doesn't have legal effect because no human mind made that decision. So in effect, that created, if you like, problems rather than solve them. So I suppose I put that in there only to say that sometimes taking away legal effect is a different legal effect, and the different legal effect may not be in accordance with people's rights in the way you frame it.
But under Dutch law, they have decided I shouldn't talk anymore, maybe. Can you hear me? Yes. So under Dutch law, we have the principle of trust. If I get a decision from the government and it says ABC, and then later the government said, oh, I didn't look properly, then unless I could have immediately understood that this was not meant for me, the government is bound. That's administrative law.
Maybe, and administrative law will be different in different countries. I suppose my point is that taking away legal effect from something is not always a positive, if you like, from the perspective of rights. In any event, I don't know if you had any thoughts on that or anything Mireille said. Any comments? We have another 55 seconds.
I will actually add one thing. Since we're talking about tax law, I always like to say a little bit more. So we have a similar situation, and so we have this automated information, chatbots or something like this in the U.S., and they actually have them in a bunch of countries. Canada has them too. And you go to the website of the tax authority, and you ask a question, and the website of the tax authority gives you a question, an answer to the question. It's generated by a chatbot, right? I think now they're using, I don't know what they're using now. It used to be a decision tree. I think, at least in Canada, I think they're using a large language model. And you're not protected in any way if you use that. If you cannot rely on it. It's not law in any sense. It has the appearance. It's on the official government website. It has the appearance of law. It is definitely generated by some kind of computer program, and you rely on it at your own peril.
In the Netherlands, we have the belastingtelefoon, the tax phone, and I have understood that in more than half of the cases, they give you the wrong answer.
Yeah, same in the United States. It's wrong. It's wrong all the time, and even when it's not literally wrong, often the answer is oversimplified and does not even apply to the taxpayer situation. It is the illusion of information, basically to push people away from actually trying to pursue information from the government, is my sense.
And the relevant question here is, could computational law solve the problem of the Dutch law students that are being paid a little money to give these answers, wrong or right, by having the law translated into computer code in a way that might end up being better? And I think that is the key question. On what does that depend? How are we going to do that, considering all the maintenance costs, etc., of software?
Okay, so we could keep going, and we will come back as a panel to all of the issues together. But in the meantime, Sarah, to present your
okay.
piece.
We did present the piece, and then at the very end we do all the conversation.
Right. So
okay, great.
So there's 10 minutes.
Got it.
10-minute reply, 10-minute panel discussion for each, and then
Perfect.
at the end
All
is
right.
audience full discussion.
All right.
If it's okay, I'm going to refer to our ceremoniemeester, Bert de Bisschop. So I have a question whether we can do a break so that Arvind Narayanan can join. It would be better to do it now than immediately after yours. So then we have a small break, like 10 minutes now, and then we continue.
Sounds good.
Thank you.
Okay, sorry. Get a short rest before your next start. You get yours all out of the way.
Yeah, that's right. And then I'll just prove. So
It's very cool.
So that I can see it. Beautiful.
Okay, I think we've got most people back. Thank you all. We're going to change around the timing a little bit for the rest of the panel to sort of try to make up a bit of time. So what we're going to have is the presentation and then the reply, but not the panel conversation afterwards. It'll be 10 minutes, 10 minutes, and then we'll move on to the next 10 minutes, 10 minutes. And then we'll have half an hour after that with everybody, panel, audience, the whole thing, which will mean we'll go 10 minutes into lunch, but not more than that. All good? Okay. On your marks, get set, go.
Okay. So you might have seen an article over the last week or so that was in a lot of different newspapers about a physicist who won his Nobel Prize for work that he did in the 1970s on quantum entanglement. And lately he's been in the news because he's a Nobel Prize winning physicist, and he's going around talking about how climate change is not real. And he has published 0 peer review articles on climate change. He has expertise, he is a physicist, but his expertise is in another area entirely. And so this would be an example of the concept of what I'm talking about in this paper of epistemic trespassing. And this is an idea that's proposed by a philosopher, Nathan Ballantyne, that gives, I think, some helpful framework that we can apply in the context of law and computation. So as Ballantyne defines this, epistemic trespassers are thinkers who have competences or expertise to make good judgments in one field, but move to another field where they lack competence and pass judgment nonetheless. And this is an example of the physicist who says, now I'm going to tell you about climate change. So that's a very prominent example, but this can arise also within academic areas as well. So there's a difference, as Ballantyne points out, between investigating questions in another field, which is fine. Everyone go around, investigate whatever you want and and holding confident opinions. And holding confident opinions is what's the problem. So what's the problem here? This can lead other people into error, and it can also take up time that can be used for actual research, because the experts have to spend time refuting the errors of the trespassers. So at issue here isn't social markers or credentials. It's about the actual ability to answer and evaluate questions and evidence. So we see this happen, I think, in the situation where technologists are proposing applications of computer science to the substance of law, the representation of law, the making or unmaking of the law. Because law is an area that actually takes expertise. It is not self-explanatory. And we heard the comment earlier today that there is a risk at having code that appears to be human readable. And I would say that law itself is already code of a different kind that appears to be human readable. But I'll give you an example. There was a few years ago, a philosophy blog had a post about a particular section of the United States tax code that related to the philosophers. It related to how certain kinds of scholarships would be treated. And it was written not in computer code, it was legal code. And these are philosophers, and their whole thing is reading difficult texts. That's kind of their whole shtick. And they could not read this. I mean, they could. It was amazing. It was amazing. It was so enjoyable. I was watching it all along, and I was like, on the one hand, I should step in here because I am a tax lawyer, and on the other hand, this is like amazing entertainment. There's absolutely no way I am stepping in here. So it was like the guy wrote the post, and then there was an update in green that was correcting the original post, and then there was an update in red correcting the original. I mean, this is hard. This is hard. It actually takes skill, and even once you're a lawyer, you don't have skills in all areas of the law. Someone who's an expert in constitutional law isn't necessarily an expert in tax law, and so forth. So this idea of epistemic trespassing is basically just a framework that we can use to think about where problems can arise. And how does one address the problem if we have questions that are hybridized? And he says hybridized, and I really like that because hybridized indicates that problems can become hybrid, right? They are not intrinsically necessarily hybrid, they can become hybrid. So what do we do with hybridized problems where you need expertise in more than one area? You can learn more about that area, but being an expert in multiple areas is really hard because being an expert is really hard. So Ballantyne, he writes, trespassing is a problem for individual thinkers, but it points towards solutions that make use of our capacity for working together. It points towards social solutions. And I think that's really where I end up. And so what are the key elements then? There are two things and they're close, they're related. One element is modesty or humility. And the other element is working together. But working together effectively requires modesty and humility. And that would be sort of the key takeaway. It doesn't necessarily require, for example, formal training in law. There are people with no formal training in law who have made incredibly important contributions to the study of legal reasoning and thinking. That's not the issue. The issue is not about a degree. It's not about a credential. It's about what kind of knowledge someone actually has. And as I mentioned before, a degree or credential can be quite misleading. It may seem that someone knows because they have a degree or credential, but that also doesn't give us the information. So it means humility and modesty about our own capabilities that allows us to enter into conversations with other people who may have expertise and then come together to find solutions, ways forward. It means that when a technologist sees something, or anyone sees something in the law, or another lawyer sees something in an area of law that they don't know about, and they say, this is ridiculous, this is stupid, something that sometimes there's a particular tweet that haunts me where another law professor referred to something in tax law. Tax law is ridiculous. I say, come over here and say that to my face. But when you have that reaction, then the question is, first, have I misunderstood this? Do I have the knowledge to discount that? And if I haven't misunderstood it, why is it that way? What's the purpose of this rule? What are the forces that have shaped this rule? What concerns, what limitations? There might be rules that aren't the ideal rules, but I can say with some confidence that in the area of law, it's not because nobody ever thought about it before. It's because of different things that pressured or shaped that decision. And so you really have to have, I think, true collaboration for the social solution. And here I would say from the side of the lawyer, and we'll see this discussed much more in later papers today, and look forward to those parts of the discussion, the lawyer really has a responsibility as well. And the lawyer's responsibility is to not give in to the temptation that I think many lawyers have to say, there's math, there's numbers, there's equations, that's science. So that must be objectively right. And we saw this happen, we've seen it happen for a very long time in the law. It's something that lawyers have desired since the 1800s, really. Not most recently, but sort of the time before last that we saw this was in the law and economics movement. The idea that there's an equation, there are graphs, this must be right. Lawyers have the responsibility to bring their expertise and to have humility around the technological aspects, but humility does not mean abdicating the responsibility to think critically either. So again, and I just sort of in closing, I would just say that the idea of epistemic trespassing is not to, I mean, here an image is going to get a little, image is going to carry it, but there is epistemic trespassing, but on the other hand, you don't want it to be gatekeeping. This isn't the idea that you have to demonstrate something, something to say, I have the right to look into this question. Everybody has the right to look into every question. The question is, how do you look into it? Right? Do you look into it thinking that whatever it is you happen to know and will come and transfer perfectly into this other field? Or do you come thinking that people in this other field have relevant knowledge about their own field and that you should listen and collaborate, have respect, have the idea that people have gone here before you and work together with people who have knowledge in the area to move things forward? And that's what I would suggest that this concept of epistemic trespassing can bring us.
I think if you start talking, it should be all right.
All right. Then I'll start talking, I guess. Okay. Thank you, Professor Lawsky, for this thought-provoking talk. To be honest, when I first read this excellent paper and I realized I would have to reply, my first reaction was alarm. The paper defines epistemic trespassing as thinkers who move into a field where they lack competence and pass judgments nonetheless. And I'm a computer scientist by training. So what could I possibly have to explain to this cross-disciplinary audience of legal experts, which would in any way or form be useful to them? But I soon realized that the very cause for my concern, the fact that I come from AI, which is a very different field from the law, could actually be useful in illuminating why AI specifically causes so many concerns around epistemic trespassing? And what is it about AI in particular that makes it so that it is trespassing across so many other domains? So over the next 10 minutes, I want to make 4 points about artificial intelligence as a product category for developers, as a research culture and a research community, and also as an object of critique by both insiders as well as outsiders. So my first point is the ladder of generality. That is, one of the defining features of computational research, and in particular AI research over the last many decades, has been this thing which I like to call the ladder of generality, together with my co-author, Arvind Narayanan. And it essentially comes down to this. So modern computing began with Alan Turing's discovery that it is in fact possible to build a single computer which can perform all sorts of different tasks. We do not need a different computer or special purpose hardware in order to solve different problems. As long as we can do very simple calculations, for instance, comparing 2 bits, any computer is essentially equivalent to any other computer across the entire world. Now, we take this for granted today, but it was a revelation at the time, and it started us up this ladder of generality because it allowed us to develop one single computer to try to solve all sorts of different tasks. The next step on this ladder was programmable computers, which had their instructions stored internally. So now, before we had programmable computers with internal storage, all of this code was actually written on punch cards. So you can imagine how much more efficient it was to build these computers, which were one more step towards this ladder of generality, one more step up. But these sorts of computers were still bound by the fact that we had to write a separate program for all sorts of different tasks. And so it is because of this reason why machine learning and AI in particular represented a huge step up the ladder. Because now we don't really need to write different programs for solving different tasks. Rather, all we need is more training examples, right? And so this shift was epitomized by the success of deep learning and neural networks at tasks as diverse as image recognition, speech recognition, and so on. So all you need are lots of examples of images with their labels. You don't really need to program the computer to be able to recognize each different type of image. And finally, the latest step on this ladder, just from a couple of years ago, is instruction-tuned AI models, things like ChatGPT, where you actually don't even need the knowledge to program these computers. You can converse with them in natural language and execute instructions like that. So at each step of the ladder of generality, the aim has been to make computing more general purpose. Now, what does this ladder of generality have to do with epistemic trespassing? So my claim is that one way to see progress up the ladder is to actually realize that at every stage up the ladder, the field of computing can claim to be at least useful, if not having solved problems in an entirely different discipline. In fact, you can see this in the central dogma of AI. So every scientific field has its own central dogma. If we were to come up with something like that for AI, it would be that the only thing we need to make progress in a completely different field or a completely different setting is just more training examples. You can see this in the wild proclamations by all of these AI experts, and this is by no means a recent phenomenon. So as far back as 1985, the natural language processing researcher Fred Jelinek said, every time I fire a linguist, the performance of the speech recognizer goes up. So there's this implicit disdain for domain experts in the field of AI, and it all has to do, my claim, is that it all has to do with this ladder of generality. In fact, for a more recent famous example, noted AI researcher Rich Sutton in 2019 had a famous essay called The Bitter Lesson. And the key takeaway of the lesson was that researchers seek to leverage the human knowledge of the domain, but the only thing that matters in the long run is the leveraging of computation. So because of this belief in the ladder of generality, the AI community doesn't pay nearly enough attention to the question of what makes different learning problems different. In other words, why is it that image recognition or advances in speech recognition would translate necessarily to advances in the law? All right, so this brings me to my third point, which is that let's say the AI community does have this belief in the ladder of generality. If they were in fact able to predict how well AI would work across domains, there might still be cause for taking these concerns seriously, right? But my third point is that the AI community in general has a very poor history of predicting the future. So in 2016, the so-called godfather of AI, Geoffrey Hinton, claimed, and I have to read this out loud and read out his quote because I would never be as confident making proclamations about another discipline. So his claim was, if you work as a radiologist, And he's an AI researcher, by the way. If you work as a radiologist, you're like the coyote that's already over the edge of the cliff, but hasn't yet looked down. So he doesn't realize there's no ground underneath him. People should stop training radiologists now. It's just completely obvious that within 5 years, deep learning is going to do better than radiologists. So this was 7 years ago. And mind you, right now, there's a worldwide shortage of radiologists. So this is an example of these poor predictions within the AI community. So then the next question is, why do these claims keep getting taken seriously? Why do we put so much stock into the proclamations of AI researchers about what this tech can do? I think part of the reason for these poor predictions comes down to commercial incentives and hype, that's for sure. A lot of these companies want to sell their tools, and so they are incentivized by financial motives to make these proclamations. Then there are also the AI researchers who are presumably, although not very well in practice, insulated from these industry pressures, right? So at its core, these claims about AI automating away our different types of jobs come about because of two reasons from AI researchers. First, at each step of the ladder of generality, it's actually truly hard to reason about what the next step would look like. So coupled with the success of the current paradigm of AI, and the most recent one is ChatGPT, it's really easy to fall into the illusory trap of making it seem like AI will revolutionize everything in every single domain. But I think the second reason has more to do with the problem of epistemic trespassing. The reason is that as AI systems and as computational systems become more general, it really becomes harder to evaluate them for what they're intended to do. And most AI researchers are not domain experts, nor do they work with such experts in most cases to understand and reason about the limitations of AI across these settings. So here, Professor Lawsky's call for epistemic humility rings true. Because as she so skillfully shows, I think legal expertise has many different layers. And if AI researchers at all want to understand how their technology will actually impact domains, they have to collaborate with domain experts. So now I want to come to the fourth point, which is that even though this characterization that I've offered so far characterizes the majority of the AI community, perhaps even the mainstream AI community, there is a small but growing part of the AI community that is in fact pushing back. So for example, in 2021, a prominent paper by Deb Raji and others was titled AI and Everything in the Whole Wide World Benchmark. They showed that a small collection of benchmarks that are aimed at evaluating general purpose technologies, things like factuality or AI tools capabilities or summarization, stand in for these more holistic domain-specific settings, which would necessarily require domain expertise. And it is this lack of domain-specific evaluation that actually leads to a lot of the issues of epistemic trespassing. So it's not just this paper, there's a prominent strain of AI ethics researchers who are actively pushing back against epistemic trespassing in the field. And a second strain of research is somewhat distinct from this first one, which is attempting to bridge the gaps between AI and the law. So a recent effort here is called Legal Bench, which brought together lawyers as well as AI experts across these different domains to work together. I think it was a paper by dozens of authors. And together they came up with a set of benchmarks which could actually inform us how well these AI tools can perform at some legal settings. And to no one's surprise, they actually do not perform very well at all so far. Finally, I want to end with a provocation, which is somewhat distinct from the first 4 points that I made, which is, could epistemic trespassing actually be useful? In other words, if done right, in some settings, could we actually try to use epistemic trespassing rather than try to fix it? So an analogy in the field of AI, again, is this practice called red teaming, where a company or a developer brings in outside experts, people who are experts in very different things like biosecurity or cybersecurity and so on, in an attempt to break their AI systems in worst case scenarios. So one example here is trying to get an unreleased AI system, let's say to output the recipe for a biosecurity weapon, or to output hateful speech and so on. So this allows developers to find and address these issues before the tool is actually released. Now, of course, such an adversarial process only works if the trespassing party does not overshadow the legal experts in the legal setting. But it could be worth thinking about which aspects of such an adversarial approach might actually be useful in our process of improving or perhaps even understanding legal systems better from the point of view of people who are outsiders or who have fresh eyes on this problem. All right, thank you.
Thank you so much.
Okay, so as per the adjusted order of events, it's still with you. But you've now got online, if we got your co-authors, are they?
I think they are online, right? Arvind Narayanan is online, I think.
Okay.
For this part, I'll use slides. So.
Okay, I'll let you. We have a slides problem.
That's okay. Can we use the slides? So sorry, it's not working. Technology. Oh, amazing.
They're up.
All right. This time I'm much louder. All right, so before I begin, first, thanks a lot to everyone who's here. I think this is a really, really wonderful event. Thank you, Professor Hildebrandt, for inviting me. My presentation is based on joint work with Peter Henderson and Arvind Narayanan at Princeton. Peter could not make it because of time differences, but I think Arvind is on Zoom. All right, so the key message of our paper is that in order to be useful for domain experts like lawyers, AI needs better evaluations, but that the current state of evaluations in AI, as I just stressed in my reply, does not really allow us to say how well it can be used for the most consequential settings. Now, as Professor Hildebrandt described in her opening remarks, as well as in her paper, over the course of the day today, we'll look at some very exciting work that tries to answer the question, what should AI be used for in legal settings from a variety of different perspectives? For example, we'll see perspectives about the procedural and normative reasons for not using AI. In contrast, our work focuses more on the technical limitations of AI and the use of AI systems in the law. So we look at 3 different types of legal applications in our paper. The first is applications requiring information processing, things like summarization, transcription, translation, and so on. The second is tasks that require creativity, reasoning, or judgment from human beings. So these include things like automated mediation, dispute resolution, perhaps even research assistance. And finally, the third type of setting we look at is tasks involving predictions about the future. For instance, things like criminal risk prediction or predicting the outcomes of court decisions. So let's start with the first category. So it turns out that language models like ChatGPT can, to some extent, do a lot of these tasks. They can be used for summarizing text, translations, transcriptions, to some extent even for e-discovery, etc. But the fact is that special purpose software, at least in the legal domain, has long been able to do so, precisely because a lot of the examples of these softwares on legal settings are narrowly constrained. For example, here's an example from 2011 from the New York Times, where the Times claimed that software can actually be used for e-discovery to some extent. What's new here with language models like ChatGPT is that a single tool can be instructed in English to perform any of these tasks. Now, that's not so revolutionary in legal applications, precisely because the tasks that are useful in legal applications are relatively constrained, but it can be useful for lay people rather than legal experts like domain experts. All right, but even so, even with the examples of ChatGPT or large language models being useful to some extent for some of these problems, there is still the problem of hallucinations. For example, here on the slide, you can see an article which was summarized using a language model, and the language model completely butchered the entire contents of the article. One intuition for why hallucinations are so rampant in legal settings is because language models generate text incrementally. So if there's an error in the first part of the output that is generated using these language models, that error is propagated downstream towards all of the other parts of it as well. And the other reason is that all of these language models are actually trained to be convincing to the humans reading these texts. For instance, techniques like reinforcement learning with human feedback actually tries to make these models more convincing to their readers. Both of these things hurt factuality.
The open question in the room is, will hallucination ever be solved? I think this is a very important sort of thing to address. And there are, in fact, many ideas for making hallucinations less likely. But the truth is, right now, a full solution for hallucinations is unlikely for the foreseeable future. That is, we don't even have any ideas or prototypes for how we can address hallucinations, let alone complete solutions. All right, so this brings us to the second type of legal application that we see in our paper, which is tasks that involve creativity, reasoning, and judgment. So if it is true that language models can indeed be useful for these tasks, it might be groundbreaking, right? Like if we can use language models or AI in general for tasks that involve human creativity, then it might be true that AI can actually change entire fields, especially in the law. And indeed, we've heard many claims, especially from companies, about how useful AI can be in these settings. So for example, the slide shows a screenshot of the news that OpenAI claims that ChatGPT can actually ace the bar exam. It gets a score corresponding to the 90th percentile test taker. And we've even seen claims that go one step further than that. For example, here on the slide is a screenshot of this company called Do Not Pay, which claims to have made the world's first robot lawyer. And down there at the bottom left is a tweet from the CEO of the company from January this year, where he said that Do Not Pay will pay any lawyer $1 million if they argue a case in front of the US Supreme Court. Now you can imagine that all of these things might make it seem like AI is about to revolutionize the law. But the reality is much sadder than all of this hype. So we've already seen cases of ChatGPT and large language models being used to fudge up legal filings. And in fact, hallucinations, the problem of hallucination is much worse for the kinds of open-ended problems that require creativity, reasoning, and judgment, simply because experts then have to go back and cross-check every single line of the outputs that they use from these models. So how can we tell if these tools are actually useful? The dominant approach in AI is something called benchmark evaluations, where a set of questions is posed to an AI tool, and we see how many of those questions are answered correctly. It offers an automated and somewhat convenient way of evaluating AI models. For instance, the bar exam is one example of such a benchmark. But there are three reasons why these benchmarks are unlikely to be very useful for AI. The first is the problem of contamination. In many cases, language models are trained on terabytes of data from the internet. So it's hard to say if a question appears in the training data itself. And if it does, then we cannot attribute the model's success to its ability to generalize to real worlds, but to its ability to memorize solutions to past problems. A second issue is construct validity. That is, are the questions we're asking these models reflective of the real world tasks they'll be used for? And here again, we know that it's not a lawyer's job to answer bar exam questions all day. So it's not really reflective of what these tools will be used for in the real world. And finally, small changes to the inputs to these tools can cause large changes in their outputs. Sometimes even things like the order in which a subpart of a question is posed can change whether a model answers a particular question correctly or not. So all of these things mean that benchmark evaluations of AI are largely unhelpful right now. Now, there are some ideas to improve these evaluations. One is the idea of transparency reports. In particular, we've seen transparency reports most predominantly in the field of social media. On the slide, you can see examples from Meta and TikTok. And in fact, EU's Digital Services Act actually requires some form of transparency from companies. So now what transparency reports do is they allow us to see how these models are actually used in the real world. For social media, this involves things like reporting how often social media is used for hate speech or for inciting violence. In legal settings, it could be how do practicing lawyers actually use these systems in the real world. Another example, and we'll see many more examples of such types of collaborations later today, is legal experts collaborating with AI experts. And so this is, the slide here depicts LegalBench, the paper that I just mentioned in my reply, which was a collaboration between lawyers as well as AI researchers. And I think it involved dozens of people coming together to see what AI can actually be used for. So both of these things can solve evaluations to some extent, or help improve evaluations to some extent. All right, so this brings us to the third type of legal application that we are seeing increasing use of, which is AI for predictions about the future. So perhaps one of the more prominent examples of such predictions are criminal risk prediction tools. So this screenshot here shows a groundbreaking investigation from ProPublica back in 2016, which showed that the COMPAS algorithm, which was used for predicting if a defendant would recidivate, was biased against Black people. Now, what stood out to me and to my co-authors from this study was not just the fact that there is bias in these tools, but that the accuracy of these tools is really, really low for white as well as Black people. In fact, the algorithm uses 137 features about each person, but its accuracy in predicting the future is as well as a layperson's judgment. In fact, a follow-up study found that the model is as good at predicting the future as a two-variable formula, the age of the defendant and the number of prior arrests. So what's astounding from this entire field of predicting the future is that an accuracy of around 65% is considered good. Professor Hildebrandt, in her remarks, said that these tools can have an accuracy of 99%. Well, we can have that conversation when these tools can actually have an accuracy of 99%. But right now, these tools cannot even predict the future much better than a coin toss. So this is one type of predictive task where predictions are used to make decisions about people in the future. Another type of task for which the use of AI has been professed is predicting the outcomes of court decisions. For instance, here we see a paper which talks about the analysis and predictions of court decisions. This paper is from 1963. So for the last 60 years, we've been trying, and it remains to be seen how successful we are, but we've been trying to predict the outcomes of court decisions before judges can do that themselves. It turns out that we've not done so well at predicting the future at all. The entire line of research suffers from some basic flaws. So for example, a seminal paper by Medvedev et al. Shows that careless data preparation in many of these cases means that the models have access to the answers themselves when they're being trained to predict these decisions. For instance, in one of the cases, the documents used is the opinion of the court, and that document is used to say what the verdict would be. But of course, it essentially contains the verdict. And when researchers have tried to remove these errors and reevaluate AI, once again, we found that the accuracy is not so good. So for instance, here's a project called Jury, which actually tries to solve this problem of contamination, and it finds that the accuracy is barely better than a coin flip. So in conclusion, there are these three types of legal applications that we look at, and it turns out that for the kinds of applications that are most likely to be consequential, that is the ones requiring creativity, judgment, as well as those involving predictions of the future, AI does not really do very well, or we need to improve the state of evaluations of AI to at least answer the question in the first place. And for the kinds of tasks such as information processing where AI can reasonably do well, the improvements are incremental. So the key takeaways from our work are that the current state of evaluations needs to be drastically improved, because to answer the question, what can we use AI for, it is essential to first answer the question, how did we evaluate this AI? Thank you.
Jetzt like so.
Okay, here we go. I'm going to sit down, and I hope it's also going to be on this monitor. Okay. So, first of all, thank you very much for this wonderful paper. I find it very impressive, and I couldn't have hoped for a better contribution straight from computer science itself, because I'm aware that it is not your everyday business to speak about the law, so you're deliciously trespassing on our domain, and we have actually invited that, though I would say this is not trespassing. Because basically you're focusing on the limitations and abilities of these technologies, and that is exactly what we want to know from you. So I'm going to discuss on 3 points. 1, will legal technologies reduce the number of lawyers and the cost of litigation, which is of course the claim that is forever made. 2nd, how about evaluating real-world deployment instead of toy examples, which is often done in academic papers on these systems. And then the distinction between generative AI, automating legal judgment, and predictive AI. So, first of all, I quote you quoting a 2011 New York Times headline read, "Armies of expensive lawyers replaced by cheaper software." And then, since the article was published, the number of lawyers in the United States had actually increased by 8%. How do we separate true advances from hype? Interestingly, one of the major outputs of our project is a typology of legal technologies. And the 2 main questions that we ask there is, first, what is the claimed functionality that the provider of that technology makes the claim? This is something we lawyers could figure out because we used only publicly available information. And then the computer scientists in the team went and looked at whether that claim is substantiated. As soon as we're talking about commercial software, that was usually not the case because of trade secret and IP rights. But the computer scientists were capable of looking at whether that could be substantiated, considering what was known about the technologies. And surprise, surprise, it turned out that most of the claims about the functionality should be looked at in the realm of PR. Interestingly, most of the claims, when you compare them with the terms of service, are sort of denied, disclaimed, like if it doesn't work as we sell it for, it's all your problem. You should have not used it or used it differently. There is this other claim that this is efficient in the sense of being cheaper. I always find that a hilarious claim, and I do not understand that anybody who has eyes and reads the financial markets can ever agree to that or buy into that. Of course, legal practice is going to be very much more expensive if we buy into these technologies. And it's not a surprise. It's like that. The same thing goes for healthcare, medical diagnosis, etc. That is not to say that we shouldn't do it, but we should never buy into the story that it's all going to be cheaper. We're talking here, if I remember well, because I can't read it from here, about, if I'm correct, 30,000 billion United States dollars in 2027, I think. Yeah. Okay, so now what I find very interesting and important in this paper is that, of course, you can do evaluation of these tools by formal methods. You can do formal verification. Then you are basically only looking at the code. You're not looking at the real world. You're also not looking at whether the question, the task, is the task that you're actually interested in. You're just looking at the code and checking whether it works as professed. That's very interesting. It's also very expensive. Usually only small parts of the code are tested in that way, but it means very little about what that code is going to do in the real world for a number of reasons. The testing, evaluating of real-world deployment has many challenges. It basically includes the question of how to move from task metrics, performance metrics on a specific task, to what type of tasks would benefit from introducing that technology. And it's very important to ask that question first, before you introduce it. And I'm reminded of a presentation that Arvind Narayanan gave. You can find it on YouTube. I've hyperlinked it. We'll put the slides up somewhere. on whether we should resist predictive AI, because that's what it's basically about, or work on harm reduction. I would say we always have to do both, to the extent that the technology doesn't do what it's claimed to do, or actually violates, has the risk of violating fundamental rights. We should, of course, resist its deployment. To the extent that it seems to work within the realm of the law and has clear benefits within that realm and does actually solve problems that we have and not solve problems that fit the technological solution that can easily be developed, yes, we should work on, if necessary, the reduction of the risk for fundamental rights, or as Anglo-American discourse will have it, reduction of harm. So in the European jurisdiction, a violation of a fundamental right does not depend on harm. So you don't have to prove harm. This is very important. The AI Act, for instance, is about the risk to fundamental rights, not the risk that somebody is harmed by the violation of fundamental rights. You don't have to prove harm if your right is violated. Note that the concept of task here, task metrics, is a technical term that comes from the domain of natural language processing, and it has a very specific meaning in that domain. So you bump into the issue of proxies that was discussed in a very interesting paper that underlies the video paper by Kapoor and Narayanan on, let's say, the fallacies of predictive AI, the optimization of predictive AI, and what are the problems there. And I wrote myself an article on the issue of proxies. So a task is a very specific computer science term. If you want to solve a real world issue, you will have to translate that into a task. There's nothing wrong with that. It's great. But you have to remember that something happens between that real world problem and its translation. So the problem you solve is not the real world problem, but the task that you have articulated. And to the extent that there's a gap between the two, you might be selling air. Okay, so the other argument here in the paper is to move from performance metrics like accuracy, and I think in terms of the law, we shouldn't look at accuracy, but at precision. So if somebody says 99 accuracy, I'm not interested. If the distribution of the data is such that the precision is 35%, for instance, the amount of false positives over the overall positives is 35%, whereas over the whole population, the accuracy is 99%. And this is what happens if you are looking for a minority in the data, so a specific distribution in the data. Stop buying into the accuracy. It doesn't matter for what you're looking for in terms of individual decisions. So, I'm trying to move to the next page. Yeah. So another thing I really like in the paper, I think I already said, is the use of the term consequential legal technologies. We are not talking here about office management, though it probably has some, or internal knowledge management of law firms, how to communicate findings of one lawyer to another. We're talking about legal technologies that have an impact, I would say, in the end, on legal effect. Then something about the distinctions between generative AI, automation of legal judgment, and predictive AI. I now heard you're putting Medvedev's work in the third category. I had the impression that in the paper it was in the second one. It is, of course, according to her own work, in the third category. And the most interesting finding, I think, is that she points out that if you train on case law, on judgments, on published judgment, and you remove the verdict, then what you're doing based on that training is not prediction, because the verdict leaks into the argumentation of the court, because the court is arguing for that verdict. So these technologies are clever enough to see that. And I think our own Pauline McBride and Masha Medvedeva now researched on 150 papers, right, where they again found that what is claimed to be prediction of outcome is identification of outcome, which can be handy if you want to scale something, but it's a totally different thing. And don't use it to prioritize cases in the backlog of a court, because then you're really doing something with the system that doesn't do that at all. Okay. I'm not going to repeat because you just summed up and somebody is shaking her hand that I have to stop talking. Yeah, so one thing then, last remark, the lack of transparency in in-house expertise. It would be very interesting to look at, in the typology there is the system that was set up by the Brazilian judiciary. And it's of course extremely important to use in-house expertise, but when we did an in-depth investigation, that didn't always come out very well. So the fact that something is done in-house, it's the same problem of, is open source necessarily better than a commercial product? No, of course not. That depends on who are incentivized to work on it, who actually work on it, et cetera, et cetera. So the problem is not necessarily resolved, I think, by in-house expertise. I'm going to shut up.
Okay, I've promised to eat into a maximum of 10 minutes of lunch, so we have just under 25 minutes. But over to anybody. Yes. Hold on, do we need a mic for the online?
Yes, good. Fantastic.
Sorry, so everyone, please wait for the mic and then quickly introduce yourself and then I'll
Gordon Guthrie, I'm a research fellow at Scottish Government, and I'm mostly kind of looking at constitutional law, though I'm not a constitutional lawyer. I thought the episode of trespassing was really interesting, and it struck me as an observation that one of the great successes of ChatGTP is that when I ask it about your incomprehensible and opaque subject, it gives me a really good, clear answer. But when I ask it about my one, it talks nonsense. It's a very effective thing there. And coming back to judiciability in law, I think one thing that's quite interesting about, there was an old thing of it must be 15 years ago, St George's Hospital they said, we've got the best medical selection process, and they did a training exercise to automate that. And then when they investigated the weights, they discovered if you were a woman, you got -5 points, and if your name had over 20 characters, was characteristically South Indian. So what happened is actually the process of AI training, particularly in relation to African Americans, reveals the bias in the human process because it's collected the data, and becomes a way to make that judiciable in a way it wasn't before. The court routinely remands black people to jail, but now we have a mechanism that's captured it. So it's my only two trespassers observations.
Anyone want to comment? That was an interesting example. I don't know. Mireille?
Well, I want to welcome Professor Arvind Narayanan. I hope I'm pronouncing the name right. He's on screen now. He is the co-author of Sanjay Kapoor's paper and supervisor. Would you like to come in with a bookmark or a question?
I just want to say thank you for having me. It's been wonderful to listen to the discussion.
I would want to make a comment back to that comment. I love the comment that you made of when I asked ChatGPT about your topic, it gives me a great summary. When I ask it about my talk, it gives me nonsense. And I think that's an enormous risk, and it ties back to this other thing that we've heard earlier today about and that I've already mentioned once, but it ties to this, which is the appearance of human readable code. And I think this is an incredible danger of these LLMs, which is how smooth they appear. And they give the presentation of, like, so far that our experience with people is that anybody who speaks that fluently is making some kind of sense, right? We're using the proxy of the way that it's presented to gain something about the knowledge, and it's completely erased. I really love that. I really love that comment, and I'm sure I'll steal it in the future. It's fantastic. My personal example of that is and this also relates to your paper, is a paper that I worked on where we asked large language models to look at some tax questions, and we had reason to know for sure that there wasn't leakage. It did very poorly on them. But one of the things was that the explanations of why it got its answers were so good that a tax person who wasn't an expert on that particular section was actually fooled by them, and it took a tax person who was an expert on that particular code section to know that they were nonsense.
There is a style of text called Barnum letters or Barnum text, which is text used by mediums and future predictors, which is written such that everyone thinks it's personalized to them. And what's interesting about ChatGTP, the responses are trained to give me a Barnum response. And it says, oh, you're so bright, you're so intelligent. And when you interrogate it about subjects you know, you can lead it anywhere, and it will say, and it just flatters you. And it's just anyway, another trespassing note.
Yes.
Professor Flores Bex.
Yes, Flores Bex. I work in computer science and a little bit in law as well, so I'm trespassing all the time. So one question, I guess maybe for Sayash, mainly is the kind of, what do you think about the idea of double standards, that we expect we talk about biased machines and machines not doing it very well. And as you nicely demonstrated, lay people don't do very well. Judges might not do very well in predicting the future. I mean, right? Well, this is my question, I think. What do you think about that? And then also going to some of the others, I guess, Mireille maybe, or Sarah. Should there be a double standard? As in, should machines do better or more transparent or more controllable than fleshy humans, right?
Thank you, Professor Bex. Can you all hear me? Can you all hear me? Okay, great. First of all, I should say I love your position paper, and I think it offers a really sort of great set of evaluations of how AI should be evaluated, like in the real world. And I also want to leave some time for Arvind to answer, because I think he's done a lot of work on this question. My take is that I think, especially with like a lot of the examples of predictive AI that we're seeing, where these human versus machine comparisons tend to take place, I think we're asking the wrong question. And I think the danger is not so much just that we'll be sort of led astray by false claims of accuracy, but that predictive tools will subtly shift our understandings of what we want from AI in these settings. So one example in the criminal justice setting is that we've had a lot of discussion about criminal risk prediction. I think in the US, many states actually require criminal risk prediction by judges to inform these decisions. What this means is that there has so far not been a focus on interventions that can help rehabilitations. So here's an example. I think a couple of years back, the Science Journal published this study where they found that in the state of New York, they found that just sending defendants a text message can meaningfully reduce the amount of recidivism. Like sending a text message on the day of their appointment reduces recidivism by 20%. This is already more meaningful than all of the gains that predictive algorithms have achieved for the last like 3 decades, right? So I think in doing so, I think our understanding of what we need or what solutions we need is shifted away to the kinds of things that are computable, as we saw in the initial talks in this setting. And so I think that is the real risk. I think we can and should use these sorts of predictive tools for helping diagnose issues, for helping us understand where there is bias in the system and so on. But when we start using them for making these kinds of consequential decisions, I think that's when the real sort of issues come in. Arvind?
Yeah, thanks. If I can add a little bit to that. I hear an echo, but I hope it's okay in the room. And just to clarify, I think Sayash meant reduce failure to appear by sending a text message rather than recidivism. What I would say about the question of human versus machine bias is that human versus machine is not the right comparison here. Machine learning systems are not being sold as replacements for individual humans, but the entire system of decision making, which is the whole distinction between rule of man and rule of law. It's not, we don't let individuals, based on their judgment, make whatever decisions they want. We've known for centuries that that is very biased, and that's why we've evolved bureaucracies and these systems in place. There are bad things about bureaucracies, but there are also good things about them, which is a bunch of procedural protections. So when machine learning comes in, it not just replaces the replacement of that individual human, but strips away all of these procedural protections. And that is well known, of course, but we've found a lot of empirical evidence of that in this paper called Against Predictive Optimization that Sayash, one of the lead authors of. And so vendors of these machine learning systems promise, when they are selling them to courts or employers or whoever it is, that it's a tool for essentially automating the decision. They're sold on that premise, but when things go wrong, they always retreat to the fine print and say, oh no, there should have been a human in the loop. It should have been the human responsibility. So, is it automation, or is it, are there still supposed to be all those procedural protections in place? That is the fundamental contradiction, I think, of these tools. And it's that bait and switch that results in a lot of things going wrong. And if we're still going to have all these procedural protections, then great. But then we lose a lot of value, supposedly, that we're getting from these machine learning tools, which is to make the process faster and cheaper and so on.
Yes, very briefly, because you already said everything I wanted to say. I always summarize this in this way. Yes, human beings may be biased. That's why we have the law. The law restricts the decision space of the court. And that restriction is institutionalized. It's not just general, abstract legal rules. It's exactly what you say. It's the countervailing powers there. I have a PhD student who's here now who is writing about the question to what extent machine learning could be used to detect bias in courts and judges, and how that could be deployed in a way that does not erode the rule of law. Congratulations and good luck, because that's a very difficult question. So it's not this simple opposition like, oh, there are these biased people and now we have this fantastically objective machine. If we can fix the bias a little bit and then put it to the same standard as a court. But what is the standard of a court? The standard of a court is a whole system of checks and balances. First instance, second instance, third instance, the training of judges, the selection of judges, etc., etc. And I think you said it exactly. That you don't want to replace.
Other? Yes.
Hi, thanks. My name is Jessica Dorsey. I'm an assistant professor at Utrecht University. I come at this from an international law background. So though I may not be trespassing, I think a lot of this is outside of my wheelhouse, which is great and fantastic. My main question, basically, translating this, I look at military applications of AI. I'm a human rights lawyer by training, concerned with protection of civilians in warfare situations. But a lot of what you all have said today resonated because the questions are similar to what we're asking as well. Specifically, Mireille, about some of your feedback on Sayash's article. How do we get industry or powerful military actors to slow down and interrogate these necessary questions? So the idea is that we're in an arms race discourse. Essentially, we have to do this, we have to innovate because our enemies are innovating. We have to stay on the edge. We have to, so we're in this arms race discourse, and the metaphors about the train has left the station abound at every single conference. Get on it or you're left behind. And that's a lot of hype that pushes investment. So I recognize the commercial side of things and the critique of the capitalist system. We can do that over drinks, perhaps. We're also seeing battlefield testing, which I think is quite different in the context of the consequences. So the risk analysis is quite different, with civilians bearing the brunt of untested systems. So my main question is, how do we demonstrate the utility of taking the time to interrogate these questions with, in a convincing way that convinces industry leaders or powerful actors that it's in their interest as well? So I'm sort of collectively trying to find maybe a hive mind way forward. So your insights are helpful, but also from the audience during the day. Thanks.
Very briefly, I always say there is this narrative like there's China, United States, and Europe, and now we have to do this because otherwise China does it, or the United States. My position, if somebody wants to run in an accelerated fashion into that wall, I can say, don't do it. It's not going to be very helpful. But I'm not going to stand in between that person and the wall. And I'm certainly not going to do the same thing. So I think when you're talking about the quality of these decisional systems, the costs of these decisional systems, I showed you some stats, and if they don't really deliver on what they claim to deliver, then those jurisdictions that are going to make providers and deployers of these systems that are not selling good quality liable are going to be better off. When you're talking about war, this is a totally different matter because sovereignty plays out in a very different way there. And the problem is that if you break down the rule of law, and at the international level, that is of course much more easy than at the national level because that's a much more contested concept at the international level. If you break it down, it will take you a very long time to build it up. So there I understand a very deep concern that if others do this, you have to do something defensive at least to make sure that democracy survives.
Any other? I'm going to throw in something actually in reaction to that, which links to the point about the importance of evaluation. So it's sort of one thing, I suppose, to say, you know, a lot of these systems don't work very well. We need to do better evaluations. We need to develop better evaluation techniques, and then we actually need to go there. But there's a different sort of meta question of how you make that happen, which I think links into the, why would any company who can sell all this stuff and make all this money, it certainly seems to be working for many organisations now, step back and do evaluations. And we've really seen, I mean, there's a whole variety of context in which evaluations are done really badly. So a few years ago, I did some research on predictive policing. This is sort of adjacent to law, but a little bit outside it. And these were systems that were very popular in the United States and started to become quite popular in England and in Europe as well. And there were a number of jurisdictions that were leaping on this bandwagon. And I looked at, well, what evaluations have been done that this works? Not just the predictive accuracy ones, the real world ones, like that it actually reduces crime and similar. And there were sort of two evaluations that had been done. One essentially proved no statistically significant impact, right? So that's not good. But the other one said it was wonderfully, it did work. The problem with that second evaluation is it was actually conducted by the founders and major shareholders of the company of the product that was being evaluated. And I'm bringing in this example because this was actually, this was a commercially successful product that was, in its time at least, until it got a little bit of bad press cut, a little bit later on, very popular, and none of the purchasers, none of the police departments that were taking up this technology asked that. They were very much relying on the sort of the marketing material that would say things like, oh, crime reduced by 80%, and, you know, I mean, he's sort of, without backing it up. So how do we do that? And maybe, Mireille, then a question for you is, to what extent will something like the AI Act mean that we actually make that happen?
Lyria knows that I'm a staunch defender of the AI Act, but while you were talking, I realized that you gave the perfect example. So the AI Act basically asks the provider to certify that their tools work as claimed. And of course, that's been criticized, and your example proves that. Why do I step into a car and trust that the engine that I don't know anything about, the brakes will work, etc., etc.? Not because we all know that at some point the car industry, or one particular car industry, decided to change the risk and say, okay, if the risk that the brakes don't work is a little bit higher, but then the cars get cheaper, so the profit goes up. It's good for the shareholders, right? And then a little bit more people die, but yeah, you know, shit happens. And this was, in the end, this went to court and it was documented. And it turned out that that was an actual consideration. And liability was established. So liability law here is extremely important. Now, does that solve the problem? Liability law is something after the fact, and it has a preventive target, of course, objective, but the question is what the AI Act, together with the AI Liability Directive, does. Is that enough? I don't think so, but to ask independent bodies to do an audit on fundamental rights risks at this moment would not work, because nobody knows how to do that. That is the motivation of the Commission, to say, okay, for now, let companies figure it out. I assume that at some point we will have a new Commission. I think next year there are elections, and at some point this will have to be adapted, because otherwise you get everybody that uses my toothpaste has better teeth, and you know, we don't want that.
What if you shifted the liability not just to the company that made it, but also the companies that bought it? So you know, like, what if you allowed some kind of cause of action for choosing to use, I mean, this could never happen in the United States, I presume, but like, what if, you know, you could have a cause of action if the police choose to use something, and as a result, you're, you know, that makes it a wrongful arrest, to the point, like, what if you spread around the liability? Because people are just responding to incentives, right? I mean, this is the most cynical view, but I think unfortunately it's the accurate view. People are just responding to incentives. And so what if you can just make the pain spread around for choosing to use these?
Yeah, so I think if you look at tort law, there are two things. You can go for damages, then you have to prove a whole lot of things, and it will take years, and the police, well, maybe not the police, but big corporations, they will go to big law, and you're done for 10, 15 years. But you can do something else. You can file an injunction. You can file an injunction, and then if you can prove that this is wrongful, unlawful, then the court can give an order and say you have to stop using this. And then they can give penalties for every day that you do use it. For very large platforms, that's a bit difficult, because how are you going to check? But at this moment, public administration should be able to. So I'm always arguing, for instance, GDPR Article 80 and 79. So the combination of an injunction and a collective action, which is not allowed for damages, but is allowed for an injunction, do it. Go after. We want to stop unlawful action, and it's not so much about damages. And somebody will have an argument against that, but you have a different question, I think.
One more here.
Yeah, so my name is Ola Al-Khatib, and I'm doing a PhD at Utrecht University on the regulation of, well, I mean, the working title is redesigning legal protection in the context of Dutch social security benefit decision making. And I was wondering about something that I'm dealing with more generally, but also some thoughts were also triggered by what was just said. But I feel that to a certain extent, if we look at the way we're trying to deal with this field, we are trying to take, and I mean we as the academic community and the field of law and computation, we are looking at certain safeguards that we have invented in sort of the analogous context, so human intervention, transparency, and we're trying to apply them to this context. And I'm just wondering to what extent, maybe in Dutch we would say, dit systeem is failliet, but maybe like this still is a good way to approach this. Maybe I can elaborate, because first of all, I was a little bit triggered by what you said, Professor Lawsky, and I linked it to an article that I read from Binns and Phil. Is that your final decision? And I think what you were describing they call an implied triage function. So if for a certain subset of the population, decisions are always overturned or not. And I mean, you have this example, but you also have both in Sensoridis and Lipsky's work, about the system level bureaucrats where everything is happening there. So then I'm like, okay, why are we focusing on human intervention if there are so many indications that doesn't work? And then on the other hand, why are we focusing on transparency? If you look, for example, at legal judgments in the Netherlands on automated decision making, but also just on analogous risk profiling. Not even that difficult, but just analogous. Then the two of the highest Dutch courts have actually said, well, okay, if you're using if you're using tools to support your decision making, then you need to comply to all sorts of transparency requirements. But I do think, and with my limited knowledge, that governments do not really do this. They either say, well, citizens will game the system if we tell them what exactly the approach is in the context of fraud detection, or I don't even think the governments actually know what they're doing because they don't keep track of it. So I'm wondering, okay, then why are we focusing on transparency? Shouldn't we sort of redesign the legal protection and more look at sort of ex ante ways to offer protection, like how can we recontextualize the rules that we currently have to make them fit more, like from a regulatory theory and law and technology perspective, how can we make them align more with this context?
It might very well take a whole thesis to answer that. So I don't know before lunch if anyone wants to make a quick comment.
I do think it's important to tease apart some areas where transparency is important and some areas where you could put some brakes on transparency. So I'm familiar with these. We have a similar situation around tax audit stuff. These ideas that you have algorithms that detect, arguably, trigger an audit or detect fraud or something like that, and you don't want to reveal them because people will game the system. But that doesn't. But the answer isn't that the switch is on or the switch is off. You can also have. We actually just had a study of this. Some economists and others were, read into some things that can't become public and found that this algorithm that you supposedly can't have anyone look at because actually was even controlling for everything else. And they have a theory about why, but they're not totally sure why. Was selecting black people for audit way too often, disproportionately, and in a way that actually was harming the fisc. If they had not been biased in this way, they would have actually had a much higher revenue from the audits, right? So is this transparency like you reveal the algorithm to everyone? No, but is it transparency in the sense of you let people really study it and see what the outcomes are? Yes, and that turned out to be really important.
Red teaming.
Yeah, I would say the goal is contestability, and transparency often has an important role. But in law, of course, like the whole conundrum about explanation of machine learning, the law is not interested in the explanation, but in the justification. So if a judge tells me, look, my dog was shitting on the carpet this morning. My wife is a big pain in the ass, and the way you wear your hair, I really dislike it. So now you're going to jail for the rest of your life. Then I will say, your verdict is not going to survive, right? So I'm not interested in all these, in opening the brains of why the judge gave me life. He will have to supply a reason. So we must learn not to be distracted about explanation. Sometimes explanation of machine learning algorithms is important, but it is only important in function of the justification. And I think we are allowing ourselves as lawyers to play the wrong language game. We're going to invest in explanation and blah, 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 blah. If somebody cannot give a valid reason, or the valid reason cannot be contested because we don't know what the algorithm did, then that is simply unlawful. And that means that system cannot be used anymore. So even judges at some point will have to learn to dare to make that decision.
I think we should be going to lunch now. Should we cut it there? Yes? Okay. Thank you, everybody. And thank you to all of our commentators, panelists, online and in person.
Thank you, Arvind, for joining us.
Oh, you
it's
might
cut
have.
off immediately.
Thank you so much.